from the signature bond that was issued to the arrest occurred.
I'm not tracking you on the signature.
Yes, Your Honor. If the court looks at the KPS that was issued, it says release option signature bond amount $2,000. I think that was intended to say $2,000 signature bond because that was the agreement we all had in court that day. And I'm fairly certain if we pull the clerk's minute sheet, it'll say essentially the same thing as well.
So this was in our court here?
Yes, sir. It was a failure to appear on the August the 16th pretrial.
I'm confident.
Yes, Your Honor.
Sorry.
And that's why I was trying to get it clarified. This is
first appearance on the underlying charge.
Yes, Your Honor. The failure to appear associated there.
What's the KPS? The KPS is on the original charge?
What happened, Your Honor, is that he was released on an ROR bond of the first appearance, scheduled for August the 16th plea day. At that plea day, he had
with what were the underlying charge on the
domestic battery by strangulation charge. At the plea day in August, we had an offer from the state for a misdemeanor battery based upon the state's conversation with the victim and an automatic early termination. Mr. King had been in touch with my office and was having car issues. He was in Georgia trying to get back in time. He also, I think since then, had been incarcerated in Georgia on other unrelated offense, which is why it's kind of been delayed a bit. The court at the time granted my request to the state's basically no objection to do it as a signature bond, considering he had maintained contact and the offer was for misdemeanor probation. At some point after the KPS was written down in this manner as a signature with the $2,000 bond, he got picked up on the FPA KPS that the court issued. That was where the recommendation came in based upon that was a $2,000 cash or professional bond. As I said, I think if we look at the 16th clerk minute sheets, it'll say on there $2,000 signature bond, which is what the intent was that day. And Madam Clerk can correct me if I'm wrong on that.
And you're saying that the KPS is unclear and that the jail has deemed this to be a $2,000 cash or professional bond?
Yes, Your Honor, based upon the first appearance that was done after the KPS.
We'll issue a decision on.
Thank you, Your Honor.
Is the offer still?
It is, Your Honor, and the state and I both have made efforts to speak to the victim in this case. I've been told through family that he's no longer wanting to pursue charges, and I'm trying to verify that information before I can really move Mr. King's case forward. Matter of fact, I tried speaking with him and his mother yesterday about this case.
Okay. So what do we need to do with this?
If we can, then, Your Honor, set him for August the 14th. My anticipation is he'll be signing himself out. And then once he does, I will be able to get his case moving forward.
Okay, so we'll reschedule at August 14th rather than August 16th in anticipation of getting out on signature.
Thank you, Your Honor. And that's all I have until 2:30, Your Honor.
Antonio Brown Jr. unrepresented.
Did the state announce this case?
Yes, Your Honor, it is. assessed, which I believe are $515 in this case. 50 hours of community service, not to trespass at the Belk and Destin where this occurred, for him to maintain gainful employment or do 2 job applications a week, for him to attend the anti-theft course and the shoplifters awareness course, no drugs, no firearms during supervision, and rating your analysis at least once a month during supervision.
So, lot of different parts to that. So, let me start over from the beginning. You do have a right to have an attorney. Are you planning on hiring a private attorney, or are you gonna want to have you believe you need a public defender?
And a public defender.
Okay. I'll appoint the public defender. Are you interested in accepting the state's offer again, not proceeding? Do you want to talk to your attorney? No, you don't want the offer, or no, you don't want to talk to your attorney?
Oh, I can talk to the attorney first.
Okay, very good. The court will appoint the public defender. The court's going to enter a not guilty plea, preserve your rights, and we'll come back on 8/14 at 9 a.m.
He's talking with Mr.
Felony? That was from this morning.
Yeah, he went back to jail, he withdrew that case, just so we could handle that with our warrants commission. And then, see, the only one, Jefferson this morning, I think.
Are you ready to go?
Mr. Gaffer's just reading over his paperwork, and then we will be ready to go.
Okay, where do you want to go next?
And then the next would be the 2 that the state were writing up the police for, and then we're done with this 130 document.
Okay.
So it's just 3 pleas left, for 130 document.
Mr. Gaffer's finished his telling me, Your Honor.
Okay, good. You're on the 230 dock, right, Mr. Miller?
Yes, sir. And the inmate for 230 won't be here for another 20 minutes.
That's fine.
Ryan Morrow for Mr. Gaffer, Your Honor. This is going to be a negotiated plea as to the VOP in 5 CF 13, 5 CF 14, and 5 CF 279. The agreement of the parties contemplates that we'll be asking the court to reinstate and modify Mr. Gaffer's supervision to such that the next 1 year will be community control, followed by the remainder of his probation's original terms and conditions. All original terms and conditions will be reimposed, including a $100 VOP fee and a $150 cost of defense. He was previously adjudicated. The pre-sentence report will not be required. I'll pause and give Mr. Gaffer an opportunity to sign. And I believe this will represent a downward departure via negotiated plea, Your Honor.
Ms. Sharpless?
This is actually Mr. Losco's case.
Where did Mr. Losco go? I'll start my colloquy, and then when he comes back, I just need to get him to.
May I approach?
Yes. Does he sign?
Yes.
Not your client's on the state.
He did, Your Honor.
Okay. Mr. Gaffer, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir, I swear.
Okay, you heard your attorney state the terms of the plea agreement,
Yes, sir.
and you can put your hand in. And I see that those same terms are contained in the written plea agreement that you've signed.
Yes, sir.
My first question is, did you read this closely?
I'm very aware of what, yes, sir.
Okay, and you've gone over it with your attorney, make sure you have all your legal questions answered,
He's
and
been very
understand what
thorough.
you're doing.
He's been very thorough.
Okay, very good. And you understand that by entering this plea, you're waiving the right to go to a trial, and this will be a final adjudication of your case. That's important. And you believe this is in your best interest?
I mean, permission to speak? I just did 20 years mandatory in prison. I've been out for 12 days. I got violated for reporting a day late. I was homeless. I don't know what's going on. I don't even know how to work my phone. And she violated me. So, I mean, I don't mind being under house arrest or supervision. I just want to work and try to and make a life, you know.
Okay.
So whatever it takes.
I know it doesn't seem that way, but we want that also.
And I
You're
thank you
part
for
of
this
our
chance.
community, and we need you to be working and doing positive stuff, and I know you want to too.
I just spent the last 20 mandatory years in prison, and it's been a rough ride. So I mean, I'm not a kid anymore. I'm really trying, and that was a violation. That I mean, they just kicked me out of prison. I didn't have nowhere to go. I didn't have nothing to eat. I was, you know.
Well, I'm going to make one little bit of suggestion to you on this. I'm going to accept your plea.
Okay.
You're going to be on house arrest and go back on probation. The key to this whole thing is making your probation officer your new best friend. In other words, stay in extra good communication. You know, make the extra call. Make sure if you're running late, you're calling, so that when there's a bump in the road, they work with you instead of booting you out on the street at the first time because you haven't been cooperating. I'm not saying you haven't.
No, I want to show you what happened. I found a job working at Julie's Southern Joy, and I'm there working. She's like, "Listen, it's rush hour. I'm going to call your probation officer for you and tell you that you're going to come in tomorrow." So she called Stephanie Howe, and the answering machine picked up. So she left a message, blah, 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 blah. This is such and such at Julie's Southern Joy. I'm going to bring Jeremy Gafford myself to court, to probation tomorrow. And she brought me there, and they arrested me. And I
Well,
explained,
like I say, when you get through, you're going to report
absolutely
to probation. Just open up the lines of communication. You know, they want you to be, I know it doesn't always seem like that, but
I'll get it right.
they want you to be successful too. They're not trying to kick you. And although, you know, sometimes the system seems like it.
It seems like that, but, you know,
But-
I just got to keep trying. So.
Yeah. You know, there's an old saying, you learn so much from playing football. I don't normally pull football analogy. There was a saying that we used to enjoy. It's like, the harder I work, the luckier I get. You know, you deserve a little luck. The way you get that luck is work it hard. Okay.
Okay, sir.
So just let me make sure and just ask you a couple questions. So you understand we're reinstating and modifying probation, so you're going to have 1 year of community control followed by the remainder on regular probation. So you're not extending your probation, but you have all the original terms and then the additional fees that got to be paid during the term.
So this
of probation.
year that I'm on house arrest,
Yeah.
it still knocks a year off of my probation from, like, because I got.
It'll be a part of your probation. Say if you got 2 years left,
Next year, so. Okay.
you got 2 years left of probation, you're going to spend a year on thing and then a year for the remainder.
Okay.
It's not added.
Okay.
Your Honor,
Yes.
Mr. Lasco went to grab the score sheet off the printer, but his notes and his text message to me do indicate that this is the state's agreement and it
And he
is.
signed it.
I can sign it for him.
No, he signed it.
Oh, you did?
I said he signed, so I'm good with that.
This, yeah, and it is a downward departure. It's based on a legitimate uncoerced plea bargain, Your Honor.
Okay, very good.
What that means.
Okay, good luck.
Okay.
Thank you, Your Honor.
So, Mr. Medina, I've got a Derek Bowman.
I have no information as to his whereabouts. I have attempted to, I've reached out to my office to try to locate him. I don't have any information. I do know, Your Honor, that my information is that he had a VOP warrant with a signature on. Or something.
Oh, yes.
On Derek Bowman.
He has a signature bond, but he doesn't
So
have a warrant.
he wasn't going to go back to jail. If there's any way that I'll make, now that I know about this issue, if we don't, if the court would consider, the state consider not entering habeas, I'll do everything I can to get him here right away, but I don't have any information.
Get him here this afternoon and we'll withdraw the capias.
Yes,
If
sir.
he doesn't show up, I'm going to order a capias without a bond. But if he can get here this afternoon, we'll withdraw it. So, Mr. Gates, Leroy figures?
Your Honor, I'm not sure what I can tell the court. I was hoping to speak with Mr. Figures this morning, or this afternoon. I don't.
Same thing Mr. Medina had to say to the court on the last case. Don't know.
All I can say, Your Honor, is I don't see Mr. Figures in court.
Okay.
I'm showing you that he was just arrested on the 18th.
And when I looked for Mr. Figures, it showed that he bonded out, so.
He was not transported with the inmates, and he was definitely on our docket, so.
So now it
That means
shows.
they looked at it and he wasn't there. Is that, am I making that assumption?
Or it may have been, they didn't know it was there.
Yes, Your Honor, it looks like it's on I don't know, because he's got a larceny charge here, and he's got booked in on a larceny charge, so I don't know if he picked up a subsequent one or not.
So he's in the jail? Okay. Well, at least he didn't get an additional KP.
I would prefer the court not to do an additional capias for him. Your Honor, if the court will allow me to enter a not guilty plea on this case, considering he's in
This
custody.
is Mr. Figures?
Yes, Your Honor.
The court will enter a not guilty plea and we'll come back on August 16th at 9.
Yes, Your Honor. He was scheduled for the 14th, but I will make a note for the 16th. Thank you. Thank you, Madam President.
The bus was a few 30 minutes.
Okay.
And I do have Mr., as you requested, Mr. Johnson. He was going to take the plea when the state wrote it up.
I don't see Mr. Costa.
Can you please advise when I can share with?
I think it's Ms. Lamont.
That's fine. This is Mr. Jeffrey Johnson. I think you were trying to put something together.
Yes, Judge. Give me one moment. Mr. Johnson, do you have any questions about this? First things first, I'm not a lawyer. If you want a lawyer to talk about this, the court can appoint you. All right, so defendant pleads guilty. You're going to be sentenced to 10 days Okaloosa County Jail, followed by 2 years probation and $515 in courthouse. You may apply for a hardship license if eligible. Okay, you're going to be adjudicated guilty. And that's it. But you do need to sign, and you're going to have to circle whether or not you're pleading guilty or no contest.
Which one am I pleading?
That's your decision. I can't tell you that.
Well, to take this plea,
Somebody in the gallery said no contract. I don't know who said that.
I don't know, Your Honor.
A friend of the court, I believe.
I missed it.
Her probation.
Your Honor, may I ask you on the, when it said, if I qualify for a hardship license, does disability consider qualification?
You know, I'd like to give you a good answer. It's not like a legal question. It's like a Department of Motor Vehicles.
Well, I've got a terminal illness, so, I mean.
No, I mean, if I had anything to do with it, I'm hearing you, but usually the hardship usually the hardship license is involving work, I think. Is that not true? The hardship license definitely to allow somebody to have a license to go to work and stuff, or?
I think there's two different versions. There's the business purpose only license, which is for business only, and then the hardship license, I think, does a little bit more that they can do.
I go to the grocery store, doctor.
I'm physically disabled, not mentally, so I can still work mentally.
Sir, I need your attention for this last part. So this is your score sheet. This is essentially your rap sheet.
Yes, sir.
Your priors are down here. You have 59 prior misdemeanors in these crimes as well. If all of this looks correct, right? And so the magic number is 44.
Yes,
You
sir.
score
I understand.
You don't score 44. So
Yes, sir.
does this look correct to you?
Yes, sir.
All right. Judge, can I correction?
You may, did he sign?
He signed? Yes, sir. It is not
Okay, very good. Just need to ask you a few questions, Mr. Johnson.
Yes, sir.
Look at you. Okay, Mr. Johnson, did I swear you in before?
Yes, sir.
Okay, you're still under oath.
Yes, sir.
So, I see that you have, the state prepared the sentence, called the sentence recommendation, it's really a plea agreement.
Yes, sir.
I don't know why we haven't named that, but I see that you signed it along with the state attorney as well, and this contains the terms of your plea agreement.
Yes,
This
sir.
is pretty straightforward. 10 days in the county jail, credit for time served. You say you've already been there longer than that.
Yes, sir.
It's not up to me, but if that's the case, followed by 2 years of probation, and then you got the court costs, and that you may apply for hardship law disability.
Yes, sir.
That's your understanding of the term?
Yes,
You
sir.
understand that by entering into this final resolution of this case, you're waiving the right to go to a trial?
Yes,
You
sir.
believe it's in your best interest to do that? I know you're not a lawyer, but do you feel like you understand enough
I do.
about how this is working and whatnot?
Yes, sir.
Do you have any questions that you have regarding this plea?
Only one is that in order to report to probation, I have to go through Walton County first because I have a hold there. So they're not going to violate me for not being there tomorrow, right?
Your Honor, I already talked with probation about that. They will see him at the jail preferably before he gets transferred. If not, then as soon as he's released in Walton, he has to report.
Okay.
Okay,
Yes,
but
sir.
they're aware of it, they're not going to violate you.
All right.
And they're here, they're writing it down,
All right, thank you.
okay?
Yes,
Any
sir.
other questions?
No, sir.
Good luck.
Right this way.
Thank you.
Question, hold on.
2 is a second degree misdemeanor, so it's 2 years commission on count 1.
The probation is 2 years on count 1, 1 year on count, or 11/29 on count 2, concurrent.
Your Honor, it's a second degree misdemeanor, so that'll be 6 months.
6 months,
Yes, Your Honor.
concurrent.
Right this way, Mr. Johnson.
Thank you.
The total is 2 years.
Geo Higgins should be next, but I want to take the plea.
Okay?
Judge, I am ready for you. So, a couple of things. First thing is I'm not a lawyer, so if you have any questions about this, you can either ask the judge or have a lawyer point. All right. That being said,
I have the attorney on this one, Your Honor.
Oh, you are?
Yes, so I can step in for Mr. Losco real quick, make it easy so he doesn't feel awkward here. Obviously, if Mr. Geohagen wants to do this, I'll move to withdrawal just to save him some money, but no contest as charged. You're going to be adjudicated guilty. You're going to be sentenced to 6 months in the county jail. Courthouse. Is there any restitution on this, Mr. Losco?
we'll reserve a restitution for 180, but I don't think there is.
And just so Mr. Geohagen's aware, I'm writing reserve restitution to, who's the victim?
The victim is his mother. Give me 1 minute.
Which one was his name? Karen Geohagen? What am I taking the plea? You got a defense potentially. I mean, I know it's your account, but you might have a defense group, but I can tell you what's going to happen. So these are the rights that we waive by entering the plea. It's a right to plead guilty, right to a trial by a judge or jury. Let me see here. And I'm on probation, so I'm not going to worry about that. All right. rights are waived by entering this plea. It's a no contest plea. Right to plead not guilty, right to a trial by judge or jury, right to be represented in the trial. Right to make witnesses come to trial, right to testify, right to cross-examine, right to appeal all matters, okay? There'll be no more trial after today, your case will be done. The judge could ask you questions about the case. He's not going to just answer it truthfully. 5 doesn't apply to you, it's only for legal purposes. 6 says you can modify your sentence if there's been a substantial change of circumstances. If you are on probation, easy, but you're in jail, so there's no reason to modify that sentence, okay? Maximum period in prison time, goes back on the front, it's going to be 5, 5. You're not getting either one of those, okay? We're going to plea based upon the facts of that motivating evidence. The adding drugs or alcohol less than 24 hours. Having nuclear incompetent or insane. Not a juvenile, not domestic, not drug related. If they take fingerprints or DNA, they may do that for another day. None of this applies to you. That's the DNA that we talked about. Reserved for restitution. There's no, you're going to pay the restitution if you're getting. They're going to save you money there. Not on probation. You haven't had opportunity to review discovery, so you're entering that without that opportunity. Any DNA evidence coming, it would exonerate you. At this point, do you have any other sentences holding you in? All right, so there's no interest. Okay, that basically says you can do administrative probation. You're not looking at administrative probation, okay? So if you will take a minute and let you read inside that.
And Your Honor, Mr. Geohagen and I were talking, he had mentioned potential defenses, and I explained to him by entering the plea, he'd be waiving all of those defenses. I know that he mentioned potential of a co-defendant in this case, but it sounds like given the time constraints, he is inclined to go ahead and just take this jail sentence. Obviously, I'd ask the court to put on the record that he is waiving the right to review discovery by entering this plea.
Very good.
All right, so here's your score sheet. Looks like you got some prior misdemeanors. No felony, so you got that. So you're going to do it, you're going to do some work, all that, that's all that fun stuff. Forever until you get your rights restored. And there's a process I can't tell you about that. I already adjudicated in 6 months.
Judge, I'm going to change the offer to a withhold. He has no prior felony history, and I don't want to adjudicate him on this count.
I appreciate that, Your Honor. I had specifically just asked the state about that, Your Honor. So, just, I'll let the court know the easiest way to do that would be to do jail as a condition of a term of probation. I would say 8 months probation. Probation terminates upon the upon his release from custody of jail. That way, we can do the withhold as well.
Correct. That's the proper way to do it.
May I approach him? And I don't think Mr. Geohagen has any objection to that score sheet either. If we can, during this time, move to withdraw, let Mr. Geohagen do this without an attorney to state under whether or not.
And I think the only other thing I would ask that the court would give him some time to pay those fees before they're sent to collection.
Do we need to put in there that this 6 months in the county jail would be a condition of the probation, and then he would?
I can always write it in the court.
Is the state okay with that? I think we need to clarify that.
I have no objection.
That's in order for him to maintain his withhold.
Right.
Okay. Mr. Geohagan, I'm going to ask you a few questions while they're tying that loose end up. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the true self?
Yes, sir.
So, put your hand. So, I just want to make sure you understand what you're doing and that you're entering into it freely and voluntarily. There's been a lot going on today. But fortunately, you got legal counsel that was able to really sit down and walk you through it. So, you heard the terms of the plea agreement. I see you signed the written plea agreement.
Yes, sir.
And were you able to feel like you got your questions answered regarding that plea agreement?
Yes, sir.
And there's some potential defenses that you'll be waiving. You understand that? That's an important consideration. You understand that?
Yes, sir.
And the way it's going to work, the key to this whole thing is you're getting 6 months sentence in the county jail. In order to withhold the adjudication, we got to kind of do something that sounds a little bit weird. It'll be a condition of your probation. Okay? So you serve the 6 months. As soon as you get out, the probation will end. So it's a part of your probation, allows you to maintain the withhold. Okay?
Yes, sir.
And your attorneys have that explained to you? Is that what you want to do, right?
Yes, sir.
Okay. And you do understand this will be a final resolution in your case?
Yes, sir.
Do you have any further questions regarding the plea agreement or what we're doing here today?
No, sir.
Counsel, anything?
Yes, Your Honor. In the time the court was discussing that with Mr. Buick, I put on there as a condition of 8 months probation, waiving supervision fees, and then 24 months from the date of release to pay those fees.
Okay. That's right. I didn't say that, and that's in there, that you got 24 months to pay them before it goes to collection.
Yes, sir.
Okay, any questions?
No, sir.
Okay. Thank you. Any questions?
Thank you.
Okay. So I appreciate everybody's efforts to try and get some of those pleas. I know that the individuals that are involved are pleased to get a resolution. I know we've only been at it about an hour and a half, and we've got several important hearings left this afternoon. I'm going to take about a 5-minute break, just quite frankly, just to stretch my legs, and then we'll come back in and we'll get going.
Your Honor, I have some plea scores for you this morning, so the court can
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients.
Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backhome Bakery Cafe is 2 blocks from the courthouse on Crestvview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boys Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
We have 6 remaining hearings today. Are there any? I know there were some discussions, maybe ongoing, regarding possible pleas. Are any of these cases this afternoon set for a plea?
Yes, Your Honor. I have one with Mr. Medina. Mr. Burns is set for a plea.
Well, let's do that first.
Well, Your Honor, I will have access to him. Mr. Gates is speaking to a client. I'm going to need 10 or 15 minutes at the most. Probably 5 minutes.
I'm not trying to rush. I just wanted to not have you wait around for a long hearing.
Oh, no, Your Honor. It will not take that long, but I do need some quality.
Since he's in there, would you like to have him sit right there? You'd rather go back?
More.
Okay.
Your Honor, if I could hear, Shea Patrick Jones, we're ready.
Thank you.
Okay.
Is that a plea?
It is a sentencing, but it should be fairly quick.
Okay.
Okay, let's do it.
Frank, Judge Ketchell, ready for Shea Patrick Jones.
Tony, would you please announce the case?
Good afternoon, Your Honor. With regards to matter 22 CF 248, State of Florida versus Shea Patrick Jones, we've had an opportunity to review the pre-sentence investigation report. I've talked to my client, and I've also talked to the state, and we're now willing to accept the responsibility and the previous cap of, I think that's 26.55 months in this particular case.
So we're changing the plea to a straight up plea?
Oh, Judge, it was a straight up plea. This was a CAP guidelines offer for Mr. Jones. He scores 26.55 months.
Right.
Just to be clear, without any basis for a downward departure today, Mr. Jones
Correct.
must be sentenced to 26.55 months.
That's correct.
Okay. So, what is the...
Well,
what do we have to do at this point?
Yeah, he just accept the sentence. Yes, he's agreeing to the 26.55 months with no supervision follow. There's no victim in this case, and it was the recommendation of the probation officer that he wouldn't be amenable to any supervised or type of supervision anyway.
Very good. Based upon the earlier agreement, the plea agreement, coupled with this, not modification, but acknowledgement about the downward departure, the court will sentence the defendant, Shay Jones, to 26.55 months. Department of Corrections, you will get credit for all time served. Do we have any fees and costs that have to be identified? I mean, I know there are some.
Standard felony costs for this matter, Judge. There is no restitution as there is no victim. The victim's
And is there, how long are you allowing the defendant to pay those after he gets out of jail? Or just go to collections?
I think collections would be best, Your Honor.
And that's fine with the state, Judge.
The court order the standard fees and costs to go to collections. And sir, you do have, even though you're more or less agreeing to this here today, well, not more or less, more, you're agreeing to this today, you do have a right, and if you feel your rights have been not been protected, you have the right to appeal this sentence that I just made. Okay? Any questions? Okay.
That's all I have.
Tony, anything else?
No, sir. Now the excuse.
You may.
This is just.
Right this way, sir.
Mr. Gates, are you ready?
We need to have a conversation with the state, if you can take mine.
Okay.
Ketchell, I can call the case whenever you're ready.
I just anticipate you're going to take me just a little bit longer. They're ready for a plea.
Okay.
If they're not, we'll proceed with yours. We ready?
I don't know, Your Honor. Honestly, I think I need a few minutes before I bring up.
Let's bring Mr. Owens. Why don't you come on up then?
Victor Stanton.
Victor Stanton.
Judge, I'm James Owens, and I represent Victor Stanton, who is before the court. We appreciate you setting this hearing for today on a motion to set bond. This is the second time we've attempted to address the bond. The first time was shortly after his arrest. Judge Terrance was the judge, and at the time, there was a federal hold, U.S. Marshal hold out of Mobile, Alabama. He was on parole. And so Judge Terrance said, no, I'm not going to address the bond because of that hold. Well, a couple of months ago, he was extradited back to Mobile federal court and was sentenced to 18 months, essentially credit for time served for the parole violation, and then brought back here. So now the circumstances have changed. This is a cold case homicide that, not sure how many years ago it allegedly occurred, and there were 3 or 4 co-defendants. All the other co-defendants bonded out, 21 months ago or so, and my client is the only one out, or only one still in custody. We've been diligently, I think the state would agree, taking depositions. There's been multiple witnesses. We've still got depositions set, I believe, in August of this year of some other witnesses. But those are the circumstances, trying to get 5 lawyers together to set depots, but we've been taking them steadily for the last 21 months. But he is entitled to a bond.
What are you requesting?
$25,000, cash or professional, and he'd be allowed to go back to Mobile to live with his father, pending the outcome of this case.
Judge Burke Davis on behalf of the state for this case. I'm sure Your Honors had the benefit of reading through the probable cause report, so Your Honor is aware that in these allegations that this particular defendant, it seems, is the person that is the one that actually pulled the trigger on this particular case. Yes, it is a cold case, but we are nearing the end of this case. We have been doing depositions diligently. We probably, if the August depositions are not the last round of depositions, then there would only be one more and we would be done with the case and prepared for trial. So we're talking about a situation that we're very close to trial point in a case where there's more pressure on both sides in a case when we get to there. So, you know, as Mr. Owens has already pointed out, this particular defendant has been on federal probation, has violated federal probation, and has just been released after doing a federal sentence. So we're not talking about somebody that has spent his time since the allegations of this case, sitting on his hands and not violating the laws. As Mr. Owens also pointed out, the state is also concerned that this particular defendant lives in the state of Alabama. He's not a local resident. So at this point, the state's belief is that he should remain with no bond. But if Your Honor is inclined to give Mr. Stanton a bond, we would ask for at least 200.
File something, setting forth. What are there was no bond?
It's charged as a second degree, Judge.
Okay. So based upon the charge, you're right on that. Okay.
If Your Honor is inclined to set a bond on Mr. Stanton's case, we would ask for at least $200,000 with pretrial services to be appointed and a GPS monitor with house arrest sanctions.
Well, Judge, if I could respond. Number one, yes, depositions are scheduled in August, and we may have one more round of depositions, and then, of course, there's going to be some motions to dismiss or suppress, so there's going to be that before the trial. So at least another probably 3 or 4 months if it goes to trial. The other thing I would like to point out is I believe that the conditions of the co-defendants, the bonds, all were set at $50,000. The reason I was asking for less is because he served 21 months waiting versus the other ones were able to bond out with a $50,000 cash and professional bond. His father is elderly. He would be living with his father. His father is actually the one that retained me, and his father could vouch for his whereabouts and swear that he would be living at his residence in Alabama, which, as you know, is about an hour and a half away. So although it's just across the state line, he's still within the geographical area, probably a couple hundred miles. So we're asking that the court consider at least $50,000. We're asking, the reason I asked for less was because of the fact that he's been in jail for 21 months. But we don't believe there's any reason it should be aggravated any more than $50,000. The fact that the others were allowed to get out at that time, for that amount.
A little different situation.
Excuse me?
Different allegation.
Well, my understanding, and excuse me, let me handle this. My understanding, you're talking about the facts. We've got it.
He's the alleged shooter.
According to an informant who evidently told him.
We're operating under probable cause. That's all I've got at this point. We're not. He's
there's some
proven guilty. And the state's got to prove their case, but we're operating today on a bond based on the probable cause affidavit.
That's correct, and they're alleging that someone in jail was told by someone else that he was the shooter. That's the evidence that they allegedly have.
Okay. Court believes there needs to be a bond. Court's gonna set a $250,000 bond with house arrest restrictions and a GPS monitor.
And pretrial services is appointed, Your Honor?
Correct.
Thank you, Judge.
Thank you very much.
Would Your Honor like to follow up with an order?
Please.
That's all I've got, Judge. Thank you.
Just so that way I'm clear before we all depart.
No.
$250,000 pretrial services, with house arrest and a GPS monitor.
Correct. Thank you.
Thank you, Judge.
Judge, I have nothing further before this board if I may be excused.
Thank you. I'm sorry? The next, Mr. Owen, next pretrial docket would be 8/16.
Thank you.
At 9 a.m. Thank you, Madam Clerk. Okay. Mr. Gates, how are we doing?
Your Honor.
I'm not trying to keep pushing this on you.
No, Your Honor.
You are actually next officially up.
Yes, Your Honor, if we can go ahead and call Mr. Gerald Green. I think we've got a resolution. I apologize for being a little.
No, that's all right. We're just trying to go with whoever's ready.
We can take Gerald Green.
I'll check and see if he leaves. I told him he went downstairs already. Can you see if he's ready?
The court will give me a minute. I'm going to lower the podium for Mr. Tony.
Would you announce the case, counsel?
Yes, Your Honor. This is Mr. Gerald Green before the court in 23 CF 693. We have a negotiated plea in Mr. Green's case. The current offer is going to be a plea of charge for 11 months to 109 days county jail. The state has asked if we could reset his sentencing to July 11th at 2:30. He would like the victim in the case the opportunity to come in and address the court about her concerns. I did speak with Mr. Green about that earlier. We had no objection to withdrawing the motion at this time and resetting it for the July 11th. He did ask if the state would consider doing an ROR bond in the meantime.
The state does not want to do an ROR. That's not appropriate in this instance, so no.
Can't do much about it. So we'll come back on July 11th. We do that in the afternoon? How long do you anticipate?
Judge, I think it's just going to be a sentencing. I'm sure that the victim is going to want to tell the court what her position is.
So we're going to set it in the afternoon?
I think so. The state's offer is 11/29. That's going to remain open. It's not going to change. But that being said, I think 30 minutes in the afternoon would work.
We'll do it July 11th at 2:30.
Thank you, Your Honor.
Thank you. Okay. Medina is not ready, and his is shorter, but I think that leaves you, Mr. Moore.
Certainly, Your Honor.
Mr. Anthony Griffin, whenever the court and state is ready, take his
We're ready.
Let's go.
Yeah, then we're ready for Anthony Griffin. That's a good thing.
And I don't anticipate a lengthy hearing, Your Honor. Just a little bit of testimony from my client and some brief argument. And as they bring up Mr. Griffin, did Your Honor have an opportunity to review a brief sentencing letter and McDonald's report?
Yes, the court has reviewed both.
And this is Mr. Griffin, Your Honor. We're here for sentencing in 22 CF 1240 and 22 CF 2457. As an initial matter, the state has stipulated the admissibility of our psychological evaluation from Dr. Randy McDonald dated 6/15/23. I've previously marked 2 copies as Defense Exhibit 1 for the clerk to file on both cases.
Very good. So, are you submitting those at this point?
Yes, Your Honor.
Any objection?
No objection, Your Honor.
Without objection, the court will admit Defense Exhibit 1. You have 2? What do you have?
I have 2. Last time we were here with 2 cases, I said I needed a copy for both
Okay,
cases.
for each
so I
one.
brought 2.
The court will admit on both cases.
And if the court needs a copy of the evaluation or the letter, I have another copy as well. And I have it digitally.
Thank you.
All right. And if it's all right with the court, I'd like to take some testimony from Mr. Griffin. He has prepared a statement for the court today. Would the court like him to remain here with me, or would like him to come up to the witness box?
You can address the court.
All right. I'll call Mr. Griffin as a witness in our case. I'll ask the clerk to swear him in.
Madam Clerk, would you swear in the witness?
Raise your right hand. Do you swear affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Yes, sir.
All right, Mr.
Slide over
Griffin.
and let him so he can speak into that.
Of course, Your Honor. Well, I don't want us to fight over this microphone. All right, Mr. Griffin, you understand you're here today for sentencing on your violation of probation case after entering admission. All right, and you prepared a statement for the court?
Yes, sir.
And you can go ahead and read your statement whenever you're ready, sir.
Thank
And
you.
I'll ask some follow-up.
Okay. Your Honor, I'm grateful for the opportunity to speak on my behalf today. I'm aware that neither you nor the state has heard of the living conditions nor the events that transpired leading up to my BOP. You see, I'm not here today because I was out running the streets. I'm not here because I was getting high or catching new charges. I'm here today because I checked myself into a rehab without my probation officer's permission. That's right, my BOP is for checking into a rehab. To understand my decision to check into a rehab, I think it's important that you understand my living conditions and what I was struggling with at the time. I was court-ordered into a halfway house in Pensacola called REAP. REAP is a program designed for inmates to transition from incarceration to freedom. My lawyer and I chose this program reasoning that it would be in my best interest to leave Fort Walton and negative influences, but little did we know that I would be moving from the kettle and into the frying pan. Drug use at REAP was rampant and at every level. I was surrounded by addicts at all times of the day, and I was distraught and on the verge of relapsing myself. I called my probation officer and asked for advice because I was terrified and knew that if I didn't leave REAP right then, I would begin using again. My probation officer recommended that I Baker Act myself into Baptist Hospital, which I did. I left immediately and spent 4 days in the behavioral health unit. But because I was court-ordered to be at REAP, once released from the hospital, I had to go back to REAP, to the same house, surrounded by the same addicts and the same problems. Your Honor, I've been diagnosed with major depressive disorder, with minor psychosis, and chronic PTSD. And while I take medication and go to therapy, these mental disorders are still a daily battle, a battle made exponentially worse by the living conditions at REAP. I made a decision to leave, Your Honor, a decision based on my physical and mental health. And while I didn't tell my PO when I left for rehab on a Friday, I was at her office before 8 a.m. Monday morning to inform her of my decision. Not only was I transparent with my probation officer about leaving REAP and why, I also continued to report weekly and was exemplary in every other detail of my probation requirements. Please don't send me to prison, Your Honor. Not only was my decision to leave REAP based on sincere concerns I also continue to follow all other probation obligations. I wasn't hiding, I wasn't running, I wasn't getting high. I was enrolled in a faith-based rehab program, continuing to report regularly to my probation officer, and I ask that you please take this into consideration today. As I've been accepted into another rehab, Project Hope is a 12-month residential faith-based rehab located in Crestview and an edifying alternative to a prison sentence. I'll be under close supervision and subject to routine drug screening. Project Hope provides structure and discipline in a safe, drug-free environment, and I humbly request that my probation be modified to include this rehab. And I thank you for your consideration.
And you recall having an evaluation performed by the defense expert, Randy McDonald?
Yes, sir.
And you were honest and forthright with her in that conversation?
Yes, sir.
And you understand you have some mental health diagnoses, correct?
Yes, sir.
Do you feel as though you benefit from medication treatment for those issues?
I have.
Do you feel as though if the court were to order mental health evaluation and treatment, that would be something that you would comply with and benefit from?
Absolutely.
Okay. I'll ask you about Project Hope. How is it exactly that you feel that you would benefit from that program?
Well, it's a drug-free environment. My biggest struggle with at the time was, was staying sober, and it's also a place to stay until I can get my feet up underneath me.
And one of the things that we're going to have to ask the court to do is essentially to downgrade your level of supervision from community control to regular probation so you can go to this program, correct?
Yes, sir.
And what kind of assurances can you give the court that despite lowering your supervision level, that this is still what's best for you and what's best for the community?
It's a 24-hour, it's not like I'll have access. I won't be able to leave, I won't be able to do anything, but stay there at the program. So it seems like maybe maybe lawfully it's less, but in reality it's more because it's a 24-hour a day, 7-day-a-week program.
Right. So you'll be supervised 24/7.
Yes, sir.
Whereas community control is just house arrest. They're just going to come
Once a
check
week.
on you with your curfew,
Yes, sir.
correct? So in many ways, this is
It's
in
more
some way a
strict.
greater level of
Yes.
supervision. It's just not through the probation department.
Yes, sir.
Is there anything else you'd like the court to know before they impose sentence today?
I know that my record doesn't reflect well on my behalf, but I would like to mention the fact that, what the cause of all the criminal activity that I've had the last 2 years stemmed from a loss that I received from somebody that I love very dearly, and I just I got sucked into a black hole of depression and made a lot of bad decisions. So it's not that I'm a bad guy, but I made some poor decisions after I was mentally distraught. And that's the precipice that has led up to me here. But I've been trying to get back, right. That's why I made a decision to go to REAP, and that's why I made a decision to go to that rehab in Pensacola, was because I wanted to stay on the right track, and I didn't want to, get back into drugs, and I didn't want to, fall down the rabbit hole I had been in.
Anything else you would have the court know to arrive at a just sentence today?
No, sir.
Those are my questions, Your Honor.
State have anything, Ross?
Sir, isn't it true that you were removed from REAP because you tested positive for crack cocaine?
Yes, sir.
No further questions.
Nothing further from the defense, Your Honor, just argument.
Does the state have any witnesses?
No witnesses, Your Honor.
Defense, you wish to make arguments?
Yes, Your Honor. Mr. Griffin's asking the court to reinstate probation and modify it to regular probation and include Project Hope as a component. As he's mentioned, it is a 12-month inpatient program where he will be supervised 24/7, and then the court can order any other conditions that they feel is necessary to ensure safety of the community and Mr. Griffin's compliance. Now, if the court is not inclined to reinstate and modify, if the court is inclined to revoke the supervision, we are asking the court to consider downward departing on the basis of Mr. Griffin's legitimate mental health condition is not connected to substance abuse. I'll refer to the DSM-5 findings listed on page 5 of Dr. McDonald's report. offers major depressive disorder and post-traumatic stress disorder. Those are both mental health conditions not connected with substance abuse. It is the position of the defense that Mr. Griffin is amenable to the treatment for those conditions, and that allows the court to find by preponderance of evidence that we can and should downward depart. We believe that Mr. Griffin is still a candidate for supervision. He is still a candidate for treatment. He has found this program. I am familiar with the issues at REAP. I used to staff Veterans Treatment Court in Escambia County, and I had many clients at REAP, and I will offer the court that what Mr. Griffin has offered in terms of what REAP is like is accurate in my experience. Unfortunately, it is a place where a lot of people go there when they're in recovery, and it does get a little rough, and it kind of turns into a place that's not the best for someone in recovery. And I understand what Mr. Griffin's saying based on prior representation and other clients that I've had at REAP. So I think that Project Hope is something that he would benefit from. I think that he would not be benefited from a prison sentence at this point. I do think that Project Hope would benefit this defendant and society, Your Honor, and I think that's a fair outcome of this violation.
State.
Judge, a couple of things I'd like to point out. The first thing I'd like to point out is that he said that he left REAP. He didn't leave REAP. He was booted from REAP because he tested positive for crack cocaine. In the process, he walked around Pensacola for approximately 3 days, did not check in with his probation officer, slept in parks, slept in cars, and Judge, he was missing for 3 days. It's undisputed that he violated his probation. We're here for a sentencing. I would say that he had his opportunity to sober up out of rehab, and instead at that rehab, he did drugs. So I want to cast this court's attention back to yesterday. This court was being very clear with a defendant who was entering a sentence that included a suspended sentence. And this court told that defendant, quote, "It's like a hairpin trigger. You don't want to mess around with these." Judge, these suspended sentences only work if they have teeth and if they're enforced when a violation occurs. And for those reasons, I am asking for 36 months DOC, which was the suspended sentence, to be enforced here. Another judge once told me that defendants teach them how to rule. I would say that this defendant, Mr. Griffin, has taught you that he's not going to be amenable to supervision. He's not going to be benefiting from rehab. At this time, I think that the only thing left to do is impose a suspended sentence. Thank you.
I'll respond just briefly to what Mr. Losco said about suspended sentences being like a hair trigger, and I understand that. But at the end of the day, Your Honor, a hair trigger is a very dangerous thing, and guns should also have safeties on them, and that is an opportunity for the court to utilize its discretion and downward depart, and we're asking the court to either reinstate his probation and sentence him to Project Hope as a component, or to downward depart on a revocation termination and sentence a new term of supervision with any conditions that the court deems necessary, Your Honor.
First of all, the court does find that there is the defense has proven with regards to the psychological evaluation that there is mental health condition, not involving substance abuse. And the defendant is amenable to treatment. So, first of all, it requires that the statutory requirement be met, and then I'm saying it's meant for your benefit, lawyers and others. Then it becomes discretionary part of the court as to whether or not there should be. This case is obviously, unfortunately, tied into the great scourge of our society, substance abuse, and trying to fight through it, a combination of mental health and substance abuse. Court finds, based on all the circumstances, that the defendant deserves another chance. I'm going out on a limb on this. One of two things is going to happen to you, sir.
Yes, sir.
Project Hope is a good program. I'm very familiar with it and worked up in Prestige for almost 2 decades. You'll have no excuses. Don't know about the REAP program, not as familiar with it. Sorry that these don't have a better reputation. One of two things is going to happen. Either you're going to be successful or you're going to be back before my court.
Yes, sir.
Sentencing you to 36 months.
Yes, sir.
You know that. So you've got all the incentives to make it work.
Yes, sir.
And you can't expect to have much sympathy if you aren't able to correct it.
Yes, sir.
So you're going to have to get up. This isn't the end, this is the beginning. So what I'm going to do is I'm placing him back on probation. Obviously, it's got to be regular probation. As a condition of it is not only the entry into Project Hope, but the successful completion.
Yes, sir.
You're on the hook all the way through it.
Yes, sir.
So when you have your bad days, and you will have bad days, you need to be thinking about the alternative.
Yes, sir.
However bad it is in there, it can be better than where you're going to go if you come out.
Yes, sir.
If you come out, they're going to catch you. You're going to be back in an orange jumpsuit. You're going to be back before the court, and I'm going to be pretty well forced on the 36 months. I'm limited to 36 months because that's your suspended sentence.
Yes, sir.
I don't take it lightly. Suspended sentences are, and you have serious issues, but the issues surrounding the violation of probation were different than the underlying issues. And I think it merits the opportunity to see it.
Thank you, Your Honor.
You can get back on track. I will, if state wishes to have a GPS monitor, I'll put a GPS monitor on. What type of additional requirements would be helpful for the state to feel that, because this is it's best I understand, it's not a lockdown program. It is a residential facility, it's not a lockdown.
Let me offer this before the state responds to the court's inquiry. I had recently sent another gentleman to Project Hope in Judge Brown's division, and at the request of the alleged victim, a GPS monitor was going to be affixed, and it ran into a lot of issues with the probation department. So I just want to raise that now for the state's awareness and for the court's awareness, because they travel, as I understand it, across state lines.
Who does?
Project Hope, for their community service work, I believe at least weekly. They're crossing state lines to.
Will you go up to Alabama?
So that's the only thing that I might say about the GPS. Ultimately, the state was gracious enough to acquiesce to the needs of the program and remove the GPS so it wouldn't cause issue. So that's all I'll say about that.
Has probation had a good experience as far as being able to coordinate with Project Code?
Yes, Your Honor, we have.
In other words, the best solution is if he's not there, you get a phone call from Project Code saying, we've got a guy that walked out on it.
Right, yes.
And are you comfortable that they would cooperate? I can't order them, because they're not under the jurisdiction of my court.
Yes, sir.
I want to make sure that probation would be comfortable interacting with them and making sure that he's where he's supposed to be.
Yes, we have an officer in the Crestview office that supervises the offenders at Project Hope and has a great working relationship with the organization.
How many folks do you have working at Project?
I don't know offhand. I know we have at least a handful.
Okay. Very good. So I'm not going to put a GPS monitor in.
Thank you, Your Honor.
Unless there's a problem. If there's a problem, I'm always open to readdress it.
Thank you.
Okay. Anything else that we need to do?
If the court's announcement of the sentence is just reinstating probation, modify to regular probation for the duration of his stay at Project Hope and completion of Project Hope as a component, and I think I have an understanding where I stand.
Well, I mean, as far as what is the term of the probation as we sit now? When would probation, and approximately,
I want to pull it directly from the clerk's
Project Hope is a year-long program, right?
Yes, sir.
So probation is longer than that. What I don't want this to be a condition in the sense that if, say it's a year and you're 2 years left on probation, then you've got to continue on probation after you get out.
Yes, sir.
Which shouldn't be,
My original probation length was 5 years.
And that's reflected.
Okay, so that needs, so we're reinstating probation. I'm not shortening it.
Okay.
But as a condition of that, you must enter and complete, and it must be, have you been approved for entry?
Yes, sir.
He has. He's been approved since January, and I believe he followed up earlier this week to ensure that they still had a place for him.
Yes, sir.
Your Honor, his scheduled term date right now is November 21st, 2027.
Okay. So you got plenty of time to
Yes, sir.
get out and reacquaint yourself with your probation work that. Okay.
Thank you, Your Honor.
Anything else we need to do?
Your Honor, is the court imposing the $100 VIP fee and the
Yes.
$150 VIP?
Yes.
The only other thing I might ask, since she's brought that up, is would the court be willing to waive his cost of supervision while he's at Project Hope?
Sure.
Thank you, Your Honor.
Your Honor, there were special conditions imposed on his original cases that were not community control related. Are those going to be reimposed on this probation?
Can you give me an example of what?
It appears like there may have been some restitution possibly.
Anything like that that was on the original, that type of thing absolutely should be reinstated. This is
Mental health evaluation and treatment.
Yes.
We would just ask for original terms and conditions to apply.
Yes, that was my intention. Okay.
Thank you, Your Honor. I believe that's all I have. May I be excused?
You may.
Thank you.
Judge, I believe that's all I have as well. Can I be excused?
You may be excused. Thank you. Mr. Medina?
Yes, Your Honor, I'm ready for Mark S. Burns. It's a rather complicated plea agreement, Your Honor.
Okay.
I took it a long time to go over, make sure he understood everything. We could get Mr. Mark Burns, sir.
We're ready for Mr. Mark Burns.
And Madam Clerk, Your Honor, if I may address the clerk as he comes out. In a sexual activity with minors kind of case, can you be thinking about what the court costs are going to be? Because I do have to fill in the blank on that. I need
$666.
Are there any surcharges or other costs, or is that the grand total?
That's the grand total.
I'm sorry, ma'am? 666. Okay. So I'm writing that in. Okay. Your Honor, Mr. Burns is signing the agreement that we've been over, and I'm just showing him the change or two that we had discussed. And he is signing the agreement that we've previously been over, Your Honor. And I provided it to him in his last court date, which I guess was yesterday, and then we talked about it more today. Ms. Basso has already signed it on behalf of the State Attorney's Office. Thank you. Just 1 second on that. And Your Honor, before I approach with the agreement, he's also providing to me, that's part of the agreement, a list of known medical conditions. And I'm just making a copy of this and providing it to Ms. Basso at her request.
Okay.
And I'll be explaining the element of the deal referencing that. Thank you.
Thank you, sir.
Thank you. May I approach, Your Honor, with the agreement and the score sheet?
You may.
And I provided probation a copy. Did you get that court cost 666 at the bottom? Your Honor, under this agreement, Mark Stephen Burns will be resolving case 22 CF 2950. There will be, first off, I want to point out, because it's not done in every case, but he is pleading guilty as charged. There will be an adjudication of guilt as charged. There will be 12 years DOC, 12 years prison on count 1 with credit for all time served, followed by 10 years sex offender probation on count 2, 5 years concurrent DOC on count 3, with credit for all time served. Sex offender designation and all statutory requirements in accordance with section 943.0435 Florida statutes. No contact with the victim or her family. And I have explained to him and have discussed it with Ms. Basso. Her family includes a child, and when and if that child were to become an adult and want to have any contact with him, he knows he's not allowed to have contact. It would be up to that person or any members of the victim's family who wanted to have contact with him to come to the court and get a modification of the sentence. GPS at lowest permissible cost, court costs of $666, $150 public defender fees. Defendant shall within 5 days provide to the state a list of known medical conditions, which I have satisfied that requirement by providing the tendered list today to Ms. Basso from the defendant. And if requested by the state, shall sign a release within 5 days of such request for any known medical records. And what the intent of that was, Your Honor, is that in the event that there was a need for medical information down the line, for whatever reason, the family, the child, whoever was appropriate could go to the state attorney's office and say, we need some information, we want a release. He'll provide that. During the DOC sentence, during the probation to follow, he's required to comply with and sign any such release in the event that that were to arise as a need. There would be $1,309.19 cost of transportation, Your Honor. I've also provided to the court the state prepared score sheet. I've gone over it with him, and he understands the score. There are no questions on the score, Your Honor.
Very good. Is the state in agreement?
The state is in agreement, Your Honor, and the victims are as well.
So, Mr. Burns, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So, Mr. Burns, I need to ask you a few questions. You can put your hand down. The purpose of my questioning is twofold. One, to make sure you understand what this deal is all about. And number two, that you're entering into this plea freely and voluntarily. Okay?
Yes.
If at any point during this plea colloquy, my questions, you want to ask, talk to your attorney, make sure you do this. This is a serious plea negotiation because it's resulting in 12 years DOC. Okay? So, you heard your attorney state the terms of the plea agreement. Those terms are also contained in the plea and sentencing agreement, which it appears you've signed. Have you signed? Is your signature here today?
Yes.
And so my first question to you is, have you reviewed this plea and sentencing? Have you read it and reviewed it closely?
Yes.
And have you gone over it in detail with your attorney to make sure you had all your legal questions answered about this plea agreement? Yes?
Yes, sir.
And you do understand that by entering this plea agreement, you're waiving a number of valuable legal rights, many of which are contained in this agreement. The right to go to a trial, the right to have the state contest, force them to prove their case beyond a reasonable doubt, confront witnesses. It affects your appeal rights, although I'm going to tell you at the end you have a right to appeal, but it does affect your appeal process significantly as well. Do you understand all of those, or are you comfortable that you got all your questions answered from your attorney about those, or anything else?
Yes, Your Honor.
Okay. And is the state acknowledging that there is, or the defense acknowledging that there is a factual basis for the entry of this?
Yes, Your Honor.
So, lastly, I just want to make sure, after having understood and gone over this, are you entering into this freely and voluntarily?
Yes, Your Honor.
Did anybody promise you anything other than what's contained in this agreement to get you to enter into it?
No, Your Honor.
Did anybody threaten or coerce you in any way to get you to enter into this agreement?
No, Your Honor.
Okay. Very good. Based upon that testimony, the court will adjudicate you guilty as charged on all counts. As to count 1 on 22 CF 2950, court sentencing you to 12 years Department of Corrections with credit for all time served, followed by 10 years sex offender probation as to count 2. As to count 3, you're sentenced to 5 years DOC. That'll run concurrent with count 1. Again, credit 4 times served. Sex offender designation, and that was explained to you correctly?
Yes, Your Honor.
Okay. And all statutory requirements in accordance with section 943.0435. Did you go over that with your attorney?
Yes, Your Honor.
Okay. No contact with the victim or her family. You understand that?
Yes, Your Honor.
That's strictly one-sided. Even if she approached you in some manner, tried to call you, you're in violation. You understand that?
Yes, sir.
You will be able to have a GPS, which is required at the lowest permissible cost. The court will require court costs in the amount of $666, $150 PD fee, $1,309.19 cost of transportation. And then, of course, you have to provide the state your known medical conditions, and that's been apparently provided. Sign a release within 5 days if there's a request for any medical records. Okay, anything further?
Your Honor, the costs and can just go to collections.
Correct, Madam Clerk.
On May 18th, there was an order to consolidate the other charges from another case into this case, leaving counts 4, 5, and 6.
The intent was that the cases would be merged. The second one should never have been issued. They did that when he came down here, basically.
I think that the agreement was, if there's would be any ambiguity because of the consolidation, would the state put on the record that any counts beyond 1 through 3 are no pros?
Any duplicative counts would then be null pros.
Okay, is that sufficient?
Yes,
To satisfy your point?
yes.
Okay. Do you have any further questions, sir?
No, Your Honor.
Anything further, Ms. Boston?
Not from the state, Your Honor, thank you.
You were going to discuss this at the
Yes, sir. You do have a right to appeal this sentence within the next 30 days. Okay?
Yes, sir.
Mr. Terrance.
Thank you, Your Honor.
Very good. Thank you all very much. I appreciate all the hard work over the last few days with a lot of these cases. We just kind of leave it.
Your Honor, it doesn't appear that Mr. Derek Bowman has appeared before the court today. I think the court had said a KBS had already been entered. It could be listed.
Court